Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today what we are going to speak about is a contractual arrangement and what happened next in relation to a client and an investment banker. Now, we have our client, sorry, I've got something sticky on my hand. We have a client and the client entered into an agreement with the investment banker. And the nature of the agreement was that the investment banker sent out an engagement letter to say to the client, hi there, this is what we're going to do, this is what we're going to charge. And the client essentially signed that engagement letter and back it went. And the nature of the engagement was that the investment banker was going to advise on takeovers and mergers and this sort of thing, and was going to be entitled to charge fees based on certain events happening and the value of certain transactions. Fine. Things move along, bids are exchanged, and there are in fact a number of bids exchanged to the extent where the court, both at first instance and on appeal, describes those bids as a bidding war. And finally, the client is sold and becomes a subsidiary of the purchaser company. And so that final transaction that both the investment banker and the client were looking towards happens. Now, what happens after that is that the investment banker sends an invoice for $50 million and a bit of change. And what the client does is say, no, no thanks, and sends a check for $20 million and resists paying the balance between that 20 and that 50 and says, no, we're not prepared to bear liability for that additional amount. So what our investment banker decides to do after that is to commence proceedings. Now, that's all well and good, and it requires the court to turn its attention to the contract, to that engagement letter that was accepted by the client. And here's where things get a little bit fiddly. Now, one of the issues in the contract is what is the transaction value, right? Because one of the types of fees, the base defense fee, among all sorts of other fees the investment banker is allowed to charge, is reliant on the transaction value, and the transaction value is defined in the contract, and it is defined based on fees, charges, and payments in connection with, those three words, in connection with the offer that is eventually accepted. Now, to give you a bit more background, and sorry to get fiddly with all these transactions, before the final offer that is accepted is made, there is a pre-bid stake taken by the purchaser. So the purchaser's made some earlier payment before making this final bid and has taken a portion of the company at an earlier time. And what the investment banker says is, oh, that pre-bid stake that happened back in the past, that is a payment in connection with the final offer. And so because it is in connection with the final offer, it forms part of the definition of transaction value. And because it forms part of the definition of transaction value, we can charge an additional fee based on that higher transaction value. Does that make sense? I hope it does. So essentially what the bank wants to say is, hey, this pre-bid stake, this earlier payment, it was made in connection with the eventual offer. And so the court has to pick apart this term. And what the court comes to find is, well, a payment made before the offer was actually made, so that pre-bid stake being taken back in the past before the final bid is made, it cannot possibly be in connection with the offer. And what the court says in support of its position is it refers to the rule of contra preferentum, which essentially holds that if there is ambiguity in a contract, and ambiguity doesn't just mean complexity or strange drafting, it means two possible competing reasonable meanings. So if there are two competing possible meanings in a contract, then the contract is to be interpreted against the drafter of it. That's sort of the short abbreviated version of what contra proferentum is all about. And so the court takes confidence here from the doctrine of contra proferentum. It finds that the contract was itself drafted by the investment banker. As you remember, it's an engagement letter that's sent out and then accepted. Its terms are ambiguous, and to the extent that it is ambiguous, that's an exposure that the investment banker has left itself open to. And so what the court finds is that the taking of this pre-bid stake is not in connection with the offer, and so it does not affect the definition of transaction value, and so does not entitle the investment banker to charge the additional fees that it had initially charged in its invoice. I hope that slightly fiddly chat about contra preferentum and engagement letters and these sorts of things was of value to you. Perhaps we got a little bit technical today, but in any case, I look forward to speaking again soon and doing so over another coffee and in respect of another case note. Cheers.